On April 13, 2026, in the 252nd District Court of Jefferson County, Texas, Defendant John W. Dixon appeared before the court for arraignment on charges stemming from a November 2024 incident. Dixon faced a second-degree felony charge of aggravated assault with a deadly weapon, specifically a firearm, after allegedly using the weapon during an assault. The proceedings captured here reveal two distinct cases: Dixon's negotiated guilty plea with a 10-year sentencing cap, and a separate bond reduction hearing for defendant Aaron Middleton, indicted for sexual assault. This footage provides a window into how Texas courts handle plea negotiations, sentencing agreements, and pretrial detention decisions.
I got you. 24 CR 2417 is now called the State of Texas versus John W. Dixon. Is it William? Wayne. Dixon, you were here with Ms. Minaldi, your attorney and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary?
Yes, Judge.
In summary, this indictment alleges that on November 2nd, 2024, in Jefferson County, Texas, you committed the second-degree felony of aggravated assault with a deadly weapon, and this was namely a firearm. You understand what you were charged with here?
Yes, sir.
If convicted, this is a second-degree felony, and you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? An agreement has been reached where you would, whatever sentence, you'll not exceed a cap of 10 years in prison. So you were looking at no less than 2, nor more than 10 years confined in prison. I guess deferred or unadjudicated probation can be assessed. And he can also get regular probation on this one,
Not
right?
from you,
Not-
Judge. He
but
would
from
be,
a jury, he
he
could.
would have been eligible for a degree, that's correct. But you can only give deferred.
All right, those are two options.
Yes, sir.
Deferred or unadjudicated probation and a flat time, no less than 2, no more than 10 years. Follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead in this indictment, sir? Guilty or not guilty? Are you pleading guilty voluntarily?
Yes,
That
sir.
is on your own free will and because you are guilty.
John Dixon entered a negotiated guilty plea to aggravated assault with a deadly weapon, accepting a sentencing cap of 10 years in prison and waiving his right to appeal. The judge conducted a plea colloquy to ensure the plea was knowing, voluntary, and intelligent before accepting it and ordering a pre-sentence report. Under Article 26.13 of the Texas Code of Criminal Procedure, trial courts must admonish defendants entering guilty pleas about the range of punishment, the right to jury trial, and the waiver of appellate rights to ensure pleas are constitutionally valid. The Supreme Court in Boykin v. Alabama, 1969, held that guilty pleas must be knowing, voluntary, and intelligent, requiring affirmative showings on the record that defendants understand and waive their Fifth Amendment privilege against self-incrimination, Sixth Amendment right to trial by jury, and Sixth Amendment right to confront adverse witnesses. Texas further requires under Article 115 that guilty pleas be supported by a stipulation of evidence or judicial confession sufficient to support the conviction. Here, the judge meticulously followed these constitutional and statutory requirements by 1. Summarizing the indictment and confirming Dixon understood the charge, 2. Explaining the punishment range, 2 to 20 years, reduced to 2 to 10 years by agreement, 3. Confirming Dixon understood he waived appeal rights, 4. Verifying the plea was voluntary and not coerced, and 5. Establishing a factual basis through State's Exhibit 1, the written plea agreement containing Dixon's judicial confession. The 10-year cap represents a negotiated plea bargain under Article 26.13b, where defendants receive sentencing concessions in exchange for avoiding trial. Plea bargaining resolves approximately 95% of criminal cases nationwide, making constitutional safeguards essential to prevent coerced or uninformed pleas. Without Boykin protections, innocent defendants might plead guilty to avoid harsher trial penalties, and courts would lack record evidence to defend plea validity against later collateral attacks. The pre-sentence report ordered here, required under Article 42.12 for felony cases, ensures the judge has complete information about Dixon's background, criminal history, and circumstances before imposing final sentence, demonstrating how procedural rigor protects both defendants and public safety in negotiated resolutions.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? State one. Did you sign that document voluntarily?
Yes, sir.
Understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No.
Without objection, it's submitted. Among other things, this states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
States Exhibit 1 is part of the record for all purposes. We are going to order a pre-sentence report. We will all return back on
April 13th.
April 13th, just in time for taxes. And everybody can sound in and the court will make its decision. Okay, good luck.
Thanks, Judge.
Okay. I don't know what happened here, but I can't get out of this. These are the only options it's given. What happened on that?
Where on the corner, remember, Judge?
Back here? Well, because it minimized it and then you're still here?
I am, Judge. Have one more.
No, me.
Is it Middleton? Yes.
Give me any hints.
I'll give you one. It's Middleton, Judge, and then the
Aaron Middleton?
to your left, Judge.
It's not it. Okay, what are we doing today here? 25 CR 906.
Judge, I have a request for a bond reduction. I have a copy of the motion if you need it.
Not got it.
I can have one too. It's just a basic bond reduction hearing and his bond is currently set at 250,000.
All right. 25 CR 906 is called. You were Aaron Middleton. You were here with your attorney, Ms. Minaldi, and the state's attorney. You have been indicted as of July of last year for the second-degree felony of sexual assault, which carries with it no less than 2 nor more than 20 years confinement in prison and a fine up to $10,000 can be assessed. Do you understand? In all bond proceedings, the court reviews the public safety report, which is a product of your criminal history that we know of. And this is all that's showing up. Have you ever been arrested before for anything before?
This is all he has, Judge.
Stand by. I'm going to look at the probable cause real fast.
Lawyers generous also. But you get a little bit more about that, this on. You're not appreciating. I don't know if it's ever been on this committee, committed on the law, no, about probation. Yeah, but if you honestly, you know, but honestly, if you look at the facts, it's interesting. It's not interesting enough to talk about. Ouch. So I think I get a little about my back on the strategy on TV. Oh, I remember the days when houses. You know what, man? You're doing great. Trying to make it's I was up there probably for a reason. Maybe I need, that's what I think. That's gonna be my next. Microsoft, turn it on. It's gonna be my next speed.
Okay. For this, the probable cause affidavit here. Anything from the state and then the defense.
Are we talking about regarding the bond,
Yeah,
Judge?
that's the what we're calling.
Judge, this was just filed this morning. I have not even had the opportunity to look into anything. She just handed it to me. This is my first time seeing it.
Go ahead, if you, the defense.
Judge, yes, that's correct. It was filed this morning. I unfortunately just had the opportunity to do it this morning. I was at the jail a lot this past weekend, but in regards to the bond reduction, and as you can see in your public safety report, he does not have any other criminal history currently. He has ties to Beaumont. He has children here. His mother is very active on this case and is very active in speaking with me about this case and about him. He has not had any.
Aaron Middleton's attorney requested a bond reduction from $250,000, arguing his lack of criminal history, community ties, and jail conduct supported lower bail. The prosecutor objected to immediate ruling due to lack of preparation time, and the judge reset the hearing for 1 week after expressing skepticism about the case facts. The Eighth Amendment prohibits excessive bail, and Texas Article 1715 requires judges to set bail sufficiently high to give reasonable assurance that the undertaking will be complied with, but no higher than is reasonably calculated to fulfill this purpose. The Texas Court of Criminal Appeals in Ex parte Rubac, 1992, established that bail determinations must consider 1. The nature and circumstances of the offense, 2. The defendant's ability to make bail, 3. Public safety, 4. The defendant's criminal history, and 5. The probability of appearance. Under Article 17.033, defendants charged with non-capital felonies are generally entitled to bail unless the state proves by clear and convincing evidence that no conditions can reasonably assure public safety or court appearance. The judge here applied these multi-factor standards by reviewing Middleton's public safety report, showing no prior arrests, examining the probable cause affidavit for offense severity, and considering the defense's community ties evidence. However, the judge also weighed the disturbing nature of the allegations, stranger sexual assault during a grocery delivery with immediate outcry, as public safety factors potentially supporting continued detention or high bail. The reset to allow prosecutor investigation of Middleton's actual financial resources and community ties reflects proper application of Rubac's requirement that bail be individually calibrated to the defendant's circumstances rather than set by formula. Bail decisions profoundly affect case outcomes. Pretrial detention increases conviction rates and sentence severity by impairing defense preparation and creating pressure to plead. The judge's expressed skepticism about Middleton's version of events illustrates how probable cause determinations can influence bail even before adversarial testing of evidence. By balancing Middleton's presumptive innocence and Eighth Amendment rights against victim and community protection, this hearing demonstrates the tension between individual liberty and public safety that defines American bail jurisprudence, and why procedural delays to gather complete information serve justice better than rushed decisions.
Issues being
She
custody.
wasn't a witness though to this event.
No one was except for the two people that were there, which is my client and Miss Williams herself.
Well, there's videos of him going in and out.
But nothing
Outside
of
place.
the alleged altercation or whether it was consensual or not. It's basically a he said, she said. So with regards to his connections to the community and the level that the bond is currently set at, right now it's set sufficiently high to make sure that he stays in custody and is not sufficiently high to.
Was the defendant, did the defendant know the complainant before this event?
I don't believe so. Did you know?
Okay, so what happens? Yeah, I'm reading the probable cause. He delivers groceries to this location. Had not known this person. Was in for 14 minutes. And then admits during the interview with the police that he had sexual contact with the person. So he's never known her. He goes and delivers groceries, leaves, and admits to having sexual conduct. Generally, grocery delivery people, that's not part of the original method of handling grocery deliveries. So, I mean, this doesn't really make sense if she didn't know him before. And then she immediately calls police and within 20 minutes after the time period, and he admits to having sexual contact with her and that never seen each other before. And that's what happens during just a grocery delivery.
Judge, I have
It could happen, but
people's sexual encounters or their preferences or what that looks like. I mean, crazy things happen every day. But in terms of whether
I bet I've been around longer than you, things can be, and this defies logic. Especially when she made an immediate outcry. Should put everybody on alert about grocery deliveries. That what can happen here is it can turn into a sexual event, which is not a good way of selling the. You're asking for what?
lesser bond that he can attempt to afford, Judge. It's set at 250 now. He has clearly not been able to make it since he's been in custody since July of last year. One that would ensure him showing up to court instead of one that ensures him staying in custody.
Judge, I would like Tom to be able to, I mean, I know defense counsel just testified to his ties to the community, but I would like to have Tom to be able to research his ties to the community as well as what he actually can afford.
This morning, Judge,
Oh.
she has,
How much time do you think you need? Is a week good? Reset this for next week.
That's fine.
Okay? On Monday.
John Dixon's guilty plea was accepted, and he was released pending sentencing on April 13, 2026, when the court will receive his pre-sentence report and impose final judgment within his negotiated 2 to 10-year cap. Aaron Middleton's bond reduction hearing was reset for 1 week to allow both parties to investigate his financial resources and community ties more thoroughly, with his $250,000 bond remaining in effect. These concurrent proceedings illustrate how Texas courts manage the competing demands of efficient case resolution through plea bargaining and careful, individualized assessment of pretrial liberty interests. These hearings reveal two fundamental pillars of American criminal procedure: the constitutional architecture protecting defendants who choose to plead guilty, and the Eighth Amendment's fragile balance between pretrial liberty and public safety. The Boykin v. Alabama requirements demonstrated in Dixon's colloquy reflect the Supreme Court's recognition that guilty pleas, while efficient, carry profound consequences requiring meticulous judicial safeguarding. Without affirmative on-record waivers, convictions could be overturned years later, undermining finality and victim closure. Meanwhile, Middleton's bail hearing exposes how excessive bail analysis inevitably intertwines with judicial assessments of guilt, despite constitutional presumption of innocence. The judge's skepticism about Middleton's account, expressed before any adversarial testing, illustrates why bail reform advocates argue for objective risk assessment tools to reduce subjective bias. Together, these cases demonstrate that procedural rigor, whether in plea colloquies or bail determinations, serves not merely defendants' rights but systemic legitimacy, ensuring that outcomes appear fair even when they constrain liberty or impose punishment. For viewers, the critical takeaway is that courtroom efficiency never justifies shortcuts on constitutional protections. The time invested in proper procedure prevents far costlier errors of injustice. Want to understand how plea bargaining really works in your jurisdiction? Research your state's Code of Criminal Procedure provisions on guilty pleas. Look for requirements like judicial admonishments, factual bases, and written waivers. Compare them to Texas Article 26.413 and consider whether your state's protections match or exceed these constitutional minimums. For bail issues, examine whether your jurisdiction uses money bail or has implemented risk-based assessment tools, and what data shows about racial or economic disparities in pretrial detention. The law lives in these details, and informed citizens make better jurors, advocates, and reformers.